Welcome back to Media7. The Official Information Act was conceived in the loftiest terms as no less than a pillar of democracy. An informed public is an engaged public. But how is it actually functioning? We'll speak to a journalist who believes it has been subverted in his case. But first, Jose Barbosa looks back.
What's he building in there? Sure as hell ain't a playhouse for the kids. Tom Waits penned these lyrics in an attempt to describe a particular kind of suburban paranoia. It's a sentiment felt by many about politics. This is the suspicion that governments are withholding, or in some cases even lying, about information that should be available to the public.
It looks like Mrs McGee's switched from underwire to soft cup. That'll help the chafing.
To ensure that the public and journalists would have access to this information, the Muldoon government created the Official Information Act in 1982.
Essentially, the bill aims to improve communications between the public and the government by making it easier to obtain information, which has been up until now very hard to get.
Anything that you are entitled to get under the Official Information Act, I warrant you will get it.
Unfortunately, this isn't always true.
Māori Affairs Minister Koro Wetere has been found guilty of breaching the Official Information Act.
The minister deliberately withheld information sought by Jimmy Hart and the Slickster when there was no good reason not to. In fact, public servants can get quite creative in their foot dragging.
Now, they can deal with this in one of several ways. One is to sort of interpret that request and give it a very, very narrow interpretation, so narrow that there's no information there at all. Also, there's a legitimate charge they can make. It's going to take X hours, and we bill out at this much, and paper is this much. Some news organisations have been sent bills for upwards, I think, $6,000 to satisfy a request. And thirdly, they can stall. While they are required to respond within 20 working days, they're also allowed to extend it if they've got good reason. Good reason is often we're very busy. For instance, been following some requests relating to South Canterbury Finance. After the letter was sent, 20 days later I got one back saying that extended by 80 more working days. Then at the end of that period they said no. This is a masterful response from Mr Wayne Eagleson, the Chief of Staff, where he uses delightful, all the tricks in the book here, including, I have interpreted your request to refer to. There he is, he's using the interpret your request line. However, they do include one particular piece of information with this release, and that was a post-cabinet press conference transcript, which is public already, but I get that, which is delightful. So an amazing play of the game by Mr Eagleson. He's a full master at it.
According to figures put together by the blogger Idiot Savant, 71% of requests to ministers between June 2009 and July 2010 were answered on time. The top 4 responders in descending order were Chris Finlayson, Maurice Williamson, John Key and Peter Dunn. The worst 4 were Jonathan Coleman, Tim Grosser, Judith Collins and Jerry Brownlee.
There is a feeling that perhaps everything's just being sanitised before release, being read over literally by a spin doctor before it gets to the hands of journalists or members of the public making requests.
So there appears to be concerns that government entities can find ways to work around the Act, which is a worry because who knows what they're building in there.
They're building a boat.
Oh, shut up, Mum!
Jose Barbosa there. Now, in the course of researching our recent program on Jon Stephenson's SAS story, we became aware of evidence suggesting that OIA requests on the same topic by journalist David Beetson had been systematically frustrated. David Beetson is with me now and he's not very happy. With him, a man who has been at the sharp end of the Act for all but 2 years of its existence, Deputy Ombudsman Leo Donnelly. Welcome to you both, gentlemen. David, I see you've brought the full folder.
No. This is just a few notes from the folder.
You've been submitting requests on essentially the same topics that Jon Stephenson was writing about and has covered in the stories. Mm-hmm. How long have you been doing that?
Since about 2006, and it's taken since then to ascertain from a minister that the cause of my original inquiry, the detentions that occurred in 2002, and what happened to those who were taken prisoner at that time by the SAS, it's taken since 2006 for us to get to the point where only a week or 2 ago Wayne Mapp stands up in Parliament and finally admits they were mistreated after they'd been handed over to the Americans. And I find that disgusting.
Was that the key question on which you were frustrated? Were
Absolutely.
there other questions?
Absolutely. Oh, yes, there were many other questions which had to do with the manner in which the PRT was being deployed. There were questions about the standard operating procedures being adopted or followed by our troops in Afghanistan, whether they were SAS or the PRT team. A whole range of subjects. What kind of diplomatic traffic passed between Kabul and Wellington and Washington. So yeah, I was all over the place, led by one document to another to another.
What impact did the fact that you couldn't get what you asked for have on your ability to report the story?
Well, fortunately, I wasn't working for anybody who was paying me a wage and expecting a result. If I had been, I'd have been out of a job very quickly. If it was anything serious and it involved an appeal to the Ombudsman, it could take a year to 18 months, which was the maximum time it took to get final determination through a process that involved the Ombudsman and the process of appeal. Don't expect anything in 20 working days except either a request for an extension or a rejection, because I can tell you now, you're going to be very frustrated if you try to work to a deadline. And I think that's part and parcel of the manner in which these things are being dealt with.
Well, let's go to the Deputy Ombudsman on that. Leo Donnelly, why might David have failed to gain satisfaction in either his original request or his appeals to your office?
The way the Act operates on a simple principle. Information should be made available unless there's good reason for withholding. The Act sets out the good reason. If your request engages one of those withholding provisions, that provides the minister or the agency the ability to refuse the request. The Ombudsman's role is the independent, if you like, the referee of the situation. Does the law apply to the situation? And I think David's request engages Section 6, which is the part of the conclusive reasons for refusal. Section 6 reasons don't require any consideration of countervailing public interest. So if the test is made out, even though one might say there might be, public interest reasons why there should be greater disclosure, if the test's made out, that's the end of the matter as far as the law stands at present.
So he got the form wrong of his initial request or his appeals?
No, I think it's the nature of what he was interested in. There are certain types of information which basically, when the Danks Committee, when the legislature passed the Official Information Act in 1982, there were certain interests that they determined were public interest reasons for refusal. If one were to look at it today, you might take a different view.
I mean, this is an interesting thing that comes up in the Law Commission review. There's an issues paper out there at the moment, and they point out that there is no good definition of what the public interest is. That seems odd and kind of inadequate in this.
Well, it depends which way you look at it. I mean, one is that if you tried to get an exhaustive list of the public interest, you'd probably limit yourself in situations where you want to take a wider view. The public interest under the Official Information Act is that starting point. Information should be available. Reasons for refusal are themselves a manifestation of public interest considerations. There is a public interest in preserving privacy. There is a public interest in protecting, the defence of New Zealand. But on top of that, in the Section 9 provisions, is the idea that even though there might be a harm, there are other considerations, which means that we should, for accountability, for transparency, for public participation, we are a participatory democracy, information should be made available anyway, even though it might be embarrassing, it might be inconvenient. But
it does seem that it's all too easy for defence to deny requests. They have that get out and they use it.
They have a strong withholding provision in Section 6A and B, and the provisions, I think David would have learnt during the course of the investigation, are not so much about the information. It's about the fact that in defence areas, New Zealand has a view that if we're trying to protect our ability to continue to get information from other countries, and it's the concern that if we were to make available information which we'd promised to hold in confidence, we wouldn't get information, we'd reduce the opportunity for cooperation.
I guess the irony is that all this information came out in the end anyway. David, I do want to get to this because we've been talking to General Rhys Jones' office about their OIA performance, and they actually came back to us with a statement promising to do better. A uniformed officer has been posted to the position of Deputy Director Corporate and Ministerial Services in the Office of the Chief of Defence Force, augmenting the ministerial coordinators. Does that fill you with hope?
No. No, but it's better than a waste bin or a revolving mail tray, which is passed from officer to officer to officer as they merrily shuffle the paper internally. And I agree with Leo's analysis. I was dealing with a very difficult area where international relationships were at stake, where there were matters of individual public safety, there were matters of national security involved. I understand all of that. But I don't see that as an excuse for obliterating everything. And my complaint is this, that while I think it's legitimate for sections of official documents to be deleted on the grounds of national security or protection of international relations, that is no excuse for withholding documents in their entirety. And I believe that if you ask for a document, the presumption is that there will be a substantial proportion of that document which is able to be provided and should be in the public domain. I think there's an absolute resistance to that. I think people are living in World War II in an age when censorship was the order of the day. Unfortunately, the age of the internet has changed all that. I can now get hold of Kabul and speak to the Red Cross about whether or not the New Zealand Defence Force has actually made an arrangement to look after the prisoners. Yes, it is.
Leo Donnelly, I wonder, the other issue that we noted in that track before was timeliness.
Yeah.
Do you have discussions with ministers and their officers about timeliness? Because it's clear that some perform and some don't.
Yeah, the Ombudsman do. I mean, essentially timeliness is an important part of the Act. The test is not 20 working days, it's as soon as reasonably practicable.
And 20 working days is not a target, it's a deadline.
It's a deadline.
Well, it's a working minimum, actually.
But, there are some cases, it depends on the urgency. There are some, Ombudsman cases, the student loans case before an election, which was done within a week. It's the question of, looking at the particular issues. Yes, there is sometimes, an overly risk-averse approach taken by officials who are concerned about making a decision which might release information which they might, otherwise sort of think should have been withheld if they had more time. But the focus of the Ombudsman is the fact that the Act, to work properly, there does have to be timely decisions. If the decisions are delayed, the information sometimes, if it comes out, you've undermined accountability, you've undermined participation.
David, just briefly, people we've spoken to who are frequent users of the Act were very much of the mind that it has its shortcomings, particularly in the way it's applied, but that the Act is a treasure. Is there anything you'd like to see changed in it?
Yes, I'd like to see more definition around how impact on international relations is going to be measured. I believe there ought to be a final legal review possible, even if it's a closed hearing. I think there should be an arbiter who is outside and above even the Ombudsman. The Ombudsman can only go so far within the strictures of the law that the Ombudsman works to. But I think that when you get to a situation where you know that people are being tortured, that our troops have detained, people have been shot in raids that weren't justified. Now you've got to actually ask some questions, and you've got to have a conscience about the people we're sending out to fight a war on our behalf.
Well, we'll see what the Law Commission makes of it. I'm quite looking forward to that review. Thank you, David Beatson and Leo Donnelly. Now, before we go, the Prime Minister has been subjected to a firm, well-structured, impeccably researched interview, free of daily political trivia. No, not New Zealand. Like Helen Clark before him, John Key was grilled for half an hour on the BBC's Hard Talk programme in London. Here it is in half a minute.
One of the country's unique selling points, that is, and your advertising slogan, I think, was all about this, about the 100% pure New Zealand. That already isn't true as your population does slowly rise, and it's going to get worse. Dr. Mike Joy of Massey University, a leading environmental scientist in your country, he said just the other day, he said, we are delusional about how clean and green we are.
Well, that might be Mike Joy's view, but I don't share that view.
But he is very well qualified, isn't he? And he's looked, for example, at the fact that half your lakes, 90% of your lowland rivers are now classed as polluted.
Well, look, I'd hate to get into a flaming row with one of our academics, but he's offering his view. I think any person that goes down to New Zealand...
He's a scientist. It's based on research. It's not just an opinion he's plucked from the air. He's one academic, and like lawyers, I could provide you another one that would give you a counter view. If anybody goes down to New Zealand and looks at our environmental credentials and looks at New Zealand, then for the most part, I think, in comparison with the rest of the world, we are 100% pure. In other words, our air quality is very high. 100%. 100% is 100%, and clearly you're not 100%. I mean, whether you agree with Mike Joy's figures or not, he says the problem is that central government, he's not just blaming you, but over decades, central government in New Zealand has been complacent about this. So what are you going to do about it?
Yeah, so I don't actually totally agree with that proposition. I mean, for the most part, you jump in any New Zealand river or stream, you go and breathe the air, and you walk up a mountain. I'd argue with you that if you don't believe it's clean and green, then you need to show me a country that's cleaner and greener.
Never let it be said that the Prime Minister does not have a view. Ask another Prime Minister, you'll probably get a different one. And that's our show for this week. Thanks again to Jon Stephenson, David Beatson and Leo Donnelly. And thanks to you for watching. We'll be back with Media7 at the same time next week. Until then, goodbye.